The Honorable Brian D. Lambert, Judge, presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good afternoon. Again, I'm Judge Lambert. To my right is Judge Soud, and to my left is Judge Boatwright. Are you Ms. Jones?
Yes, sir.
Could you approach the podium, please? Okay, all right, Ms. Jones. We're here. It's in case 23-553, Keyshawn Xavier Glover versus State of Florida. We're here today because we issued an order on March 15, 2024, directing you to appear before us at this time to respond to our inquiry as to whether sanctions should be imposed regarding your conduct representing Mr. Glover in this case. A couple things. Let me just make sure. How do you pronounce your first name, ma'am?
Yolanta.
Yolanda? Did I say that right?
Yes, sir, you did.
Okay. And your bar number is 23750?
Yes, sir.
And you currently are a practicing member of the Florida Bar?
Yes, sir.
How long have you been a member of the bar?
Since 2006, I believe.
2006?
Yes, sir.
Could you move over to the microphone a little bit?
Yes, sir.
Thank you. That's a lot better.
I
Thank you very
apologize.
much. Okay, as an officer of the court, I'm going to assume that all the responses that you give to either me or to any of the panel members who have questions are truthful.
Yes,
Fair,
sir.
fair understanding. Who are you currently employed by?
I currently work for the Office of Regional Conflict Counsel in the 1st District, 1st Region.
And your office is where?
It's in Duval County, Florida.
Okay, Jacksonville.
Yes, sir.
And how long have you worked for them?
Since 2020, August of 2020.
What, and if I'm understanding correctly, did you represent Mr. Glover at trial?
Yes, sir.
All right. Is that primarily what you do for the Conflict Counsel Office?
Yes, sir, as defense counsel.
Have you ever handled an appeal?
We file the notices of appeal. Beyond that, it transfers to another public defender's office to file the actual appeal.
Right. I mean, that's what I understand typically with indigent defendants. I mean, Judge Soud and I, we used to be on felony dockets, and Judge Boatwright was on the county docket, but on appeals, that's how I always understood when in the Fifth Circuit where I presided, the PDs would file the notice who represented the defendants at trial, but then eventually here, the Seventh Circuit PD in Daytona would represent the defendants on appeal.
Correct.
So I guess I'm not understanding. Have you done an appeal before?
Independently, no, and that's
Is this, I mean, so you're the attorney of record right now?
correct. And I think what eventually should happen is it transfer to the Seventh Circuit. So that's, I think, where the issue
Why
is.
did that not happen here?
I don't know, Your Honor. We filed our notice of appeal in January. I recall receiving a phone call from the, I don't want to say the first, and I'm sorry, I don't know, the AG's office, and they had indicated a request for a belated appeal, and if I had any objection to that, and they indicated that they saw in CCIS that our appellate notice had been filed and that they didn't see any problem, but they wanted to confirm with us. I obviously told them absolutely not. I don't know what the issue is, and thought the issue had been done. Apparently,
Well, let me ask, from a paperwork standpoint, when you file the notice of appeal, and then you're indicating typically that's what you do
Yes, sir.
on cases that your clients at trial wish to pursue an appeal.
yes, sir.
And you actually filed the notice of appeal. It was a case that was ours. It wasn't a transferred case from the first DCA. The notice of appeal that was filed by you was on January 6th. So in other words,
Correct. I think it would have been filed in the 5th properly, very close to when the transfer from the 1st to the 5th.
right. I mean, it's filed below at Duval County, in the circuit in Duval County, but it wasn't one of these that got lost in the shuffle from the first DCA transfer cases to us.
It was not previously filed in the 1st, if
Right,
that's what you're
right.
asking.
So, I mean, so what is the paperwork historically that you've done when you have handed off to the appellate PDs?
That honestly is sort of automated. We have, I guess, an appellate department. We file our notice of appeal and send the requisite requests, and then those transfer over. I'm on the front end of that. I don't know, quite frankly. I'm aware, obviously, that since that time, there had been orders of the court that were sent through from this court to my 50CA account, which had an old email address on it.
Why would you have had a 50CA old portal or email address?
I didn't know I had a 50CA account. I don't independently file. That's done with the office. I think they were still using I don't know if we had to go in and they transferred from the 1st to the 5th or what the portal looks like, but there's apparently an account, and it had my old state attorney email address on it, which seems to have been where the holdup was in terms of responding to your inquiries.
You were referencing the AG's office contacted you about a belated appeal in this case?
Yes, sir.
Do you know or recall when they had contacted you about that?
Oh, it was definitely in 2023. I mean, it was a little
I mean,
ways ago.
contextually, what had happened, at least in our record, is that your client filed a petition for the belated appeal, a pro se petition, because he wasn't sure what was going on in his appeal, and his family found out that his appeal had been dismissed for lack of prosecution. So he filed a petition back in October of 2023. And so, using your answer right now, I would think that the AG's office at some point contacted you sometime after that, but during 2023. By that time, there had been several orders entered in this case by us that you did not, by our court, that you did not respond to, that led to the dismissal of the case, et cetera. What action did you take at that point when the AG's office contacted you about your client seeking a belated appeal, when you knew you had filed a notice of appeal? So in theory, it would be no reason to file a belated appeal petition when you had timely appealed the judgment and sentence below.
The conversation was rather quick. The question from the AG's office was, do you have any objection to this belated appeal? My independent office doesn't actually write the appeal, so I didn't know if there had been an issue on the back end. I didn't realize that that came through a pro se defendant. I didn't know that it was from Mr. Glover himself filing a request for a belated appeal rather than, say, appellate counsel requesting it. I didn't know, and it was a very quick conversation with the AG's office. So I didn't realize it was himself doing it, and I guess in retrospect, hearing the word belated, I should have dug further, I guess. Honestly, it was a quick conversation. The AG's office did not appear to be concerned about it, and just merely asked if we had any objection, to which I obviously said no, and that was the end of it. That was all they asked.
But it didn't raise a red flag as to why, if I filed a notice of appeal, why is there being an ask for a belated appeal? Because you were the trial attorney, so you would know that you filed it timely, the notice initially.
It was, again, Your Honor, it was such a quick conversation, and it didn't spark any question from the AG's office. They did not appear to be concerned, and I just didn't read any further into it, to be quite honest, Your Honor.
And your practice is exclusively trial court litigation?
It is, Your Honor.
And
yes,
so perhaps not perceiving, at least on the face, a context for what that would have meant from the appellate realm.
In retrospect, I certainly realize it should have triggered me to do some further digging. Absolutely, in retrospect. At the time, I didn't even give it a second thought, to be honest.
Who is Candace K. Brower?
She is the elected head of the Office of Regional Conflict Counsel.
So she's your boss?
Yes, sir.
Okay. And
Statewide or Region 1?
Region 1.
okay. Is she in the office there in Jacksonville?
She's not in the Jacksonville office. The first region includes Duval County, all the way up through Tallahassee in the Panhandle, and some areas in the Lake City area.
Well, you filed a response to the order here about when we directed that you file a response to this March 15 order, and basically, I'm paraphrasing, is that you became aware of these circumstances that we're talking about today because Candace Brower notified you about this. Is that your
Yes, sir. What actually happened, I guess there was an order that went to Ms. Brower and the appellate portion of the office. That's how they became aware of it. That was the first time that any order reached our office, and obviously very quickly resulted in an audit of, email addresses and accounts and all of those things to avoid and prevent any such thing happening again.
Well, one of the concerns I have then is, so the March 15 order, the one that tells you to be here, that's what your position is that's when you first became aware that there was problems? I'll use it broadly.
No, sir. I looked back and looked through all my notes, and I received a phone call from Sheila, I believe, from this office shortly before that, and she indicated that there had been some orders and asked if, we were aware of them, and I indicated I obviously had not and would not intentionally fail to respond to any orders from the court. I was in trial and, quite frankly, then was into car accidents, and it slipped my mind to go check it at that point. And so the next thing I knew, this order had occurred, and here I am.
Well, the sequence of the notes that we're aware of is, we have the March 15 order. There's also a February 2024 order that it basically said, upon consideration that you'd failed to respond to our court orders, you were directed to show cause why sanctions should not be imposed, and you did not respond within the 10 days. That order, according to the certificate of service, went to Ms. Brower, and it just seems odd to me why Ms. Brower, when she gets that, and she's your boss, she's the boss, I guess, wouldn't be notifying you, and then you respond to us before we had to issue the March 15 order that brings you here today.
I've never seen that order, Your Honor. I don't know, and I'm not aware that they've seen it. When the order directing me to appear arrived, I can assure you they immediately contacted me, and we started looking to see what was going on. So I can't speak to that service or how it was not noticed. I can't imagine that she would have gotten it.
The difficulty or the question or the red flags that's raised is, all right, you get the March 15 order, or you become aware of the March 15 order because your boss tells you, said, hey, you got this thing that says they want you to appear in person as to why you shouldn't be sanctioned, and they want to personally talk to you. And I assume that's something your boss preferred, and obviously you would prefer not to have ever had to occur.
Absolutely.
And I get that. But there's an earlier order that went to your boss on February 20 saying, so she can read it. I assume she got it in the same way. I assume she got it in the same way that she got the March 15 order. And it just strikes me as odd when she sees one of her employees being ordered by this court to tell us within 10 days why you should not be sanctioned for your failure to respond to our court orders, that she doesn't immediately contact you as the boss saying, hey, what's going on here?
I don't know, Your Honor. I received, when the most recent, the March 15th order appeared, we received an email from our appellate department and said, we just got this from the 5th DCA. That's the only order that they tendered. I don't know about that prior one from February, Your Honor.
Well, the notes we had, you're referencing, since you brought it up, you referenced Sheila, your conversation with Sheila here. Sheila Stanbro is the assistant deputy clerk here at the assistant clerk of the court to our court here, and the timing of the notes seemed to indicate it came after our January 25, 2024 order to show cause that you would indicate you hadn't received, and the February 20 order to show cause, which is the one just before that, and it mentions that Sheila spoke. She says, I don't know what else to do here. I've emailed her, you, spoken with her secretary, and spoke with you personally, and it indicates you were very concerned, and you said you would fix it and file something right away. Okay, that's sometime, certainly more than a month before we issued the order to show cause. Why? that's indicative, and it sounds like from your own volunteered statement that you were notified personally by the clerk of court here, deputy clerk of court, which I assume you would think is an unusual thing to have happen, absent that they're being concerned that they need something to be done.
Yes, sir.
And it didn't seem to spur the reaction, and the only thing that spurred any kind of written response from you was this March 15 order that says you need to be here to talk to us personally. I mean, you're being told that there's orders that you have to be addressed, have been ignored by you. We don't know what's going on. Sheila is reaching out to you saying, please do something. This isn't going well for you. And that doesn't, I mean, I'm trying to think back when I was a lawyer, and that's a long, well, I guess I technically still am, but I mean, back when I practiced law,
Yeah.
if
And
I
don't-
had a judge contact my office, I mean, almost my heart would stop, like, hey, what did I do? Where do I need to do? I'm so sorry, let me go. And that, you know, that was circuit court level, and here we're trying to, you know, we have the Marcy's Law overhang here that we have to get appeals done, and this case has languished for a year and 3 months without any briefing or anything, and you're reached out to.
And I don't have any excuse, Your Honor. I can explain, but
Yeah, I
I'm
mean,
not
I'm
offering this in
certainly would
any
give you
manner
a-
as an excuse. You know, I got that phone call from Sheila in the midst of a trial. I did speak with her, I recall that now, and then after that, I continued to be in trial, and I was in a car accident, and it slipped my mind, and I offer no excuse for that, Your Honor. It's,
What, you know, part of the process here that we have is why should we have a comfort level that that won't happen again with you?
Since that time, Your Honor, we have gone through, we've verified not just my email address, but everyone else's in our region as well. The secondary address that is on there is not one that's affiliated with myself, but someone else that's affiliated with the office, so that it not only goes to the attorney of record, but it now also goes to additional staff to ensure that any order that comes through, if it's missed for whatever reason from the attorney, if they're out of town, if they're not accessing their, whatever it is, that it's also going to someone else, and that from there it can be added to the file or notified with appellate counsel. So we've remedied that on that end to ensure that something like that would not occur. Your Honor, I am beyond embarrassed to be standing here right now having this conversation. I don't know what other further assurances I can give this court other than to say that I've never had anything like this happen, and I can assure the court that it will not ever occur again.
So I guess, so following up what you just said, so you've never been sanctioned or called to task by a court to? I mean,
Never.
we're all called to task to behave ourselves when we're trying. We get all that, but I mean,
Never,
you've
Your
never
Honor.
said, you've never been called in to say, hey, we're concerned about your
Not at
behavior.
any court level, Your Honor, never.
I'm sorry.
Not at any court level, Your Honor.
And the scenario that happened here, I mean, because I've got to think that you have filed notice of appeals, if you've been a lawyer and in the criminal arena for the number of years you've indicated. So you've never had a scenario where you filed a notice of appeal and the handoff to the appellate PD's office did not take place. This is the first time this has ever happened?
That's correct, Your Honor, that I'm aware of. Your Honor, my experience prior to being with the Office of Regional Conflict was with the State Attorney's Office. I never had an issue with a filing on that end. With regional conflict, I think I'd only filed one other appeal. So no, I have not had any tracking. I honestly didn't know what, if any, emails or confirmation we'd even receive.
I mean, because it begs the question, when you file a notice of appeal, and you know, if you're the one actually doing the appeal, you kind of say, well, I filed it in January of 2023, there's going to be a time for me to get a record and to do something here, and, I mean, there's no inquiry from you to the court about, well, I haven't gotten a record, I haven't heard anything, and what's going on, you know, calling up, I mean, you wouldn't have known Sheila back then. But, you know, finding out, well, why is the case not processing here? There was no red flag, but I guess your explanation is, well, once I file the notice of appeal, it goes to somewhere else, and I'm not the actual filer of the brief or monitor.
Correct, we don't actually write the briefs, correct.
Do you get something when you file a notice of appeal where that shows that some other, I don't know if it's the 7th Circuit PD office here that handles it, or the 4th Circuit? I don't know I don't recall who's handling the PD appeals out of Jacksonville now.
I think it is still the 7th, I think
I mean, I know
that's
your
accurate.
regional conflict, but.
Not that I'm aware of. I suppose maybe there should be, but I'm not aware of any.
So once you file your notice of appeal, I'm familiar with Jacksonville, the felony,
Yes, sir.
the load RCC carries, the load the public defender's office carries. And so obviously, listening to you, and I want to be clear with you, the purpose of the hearing today is not to make anyone a spectacle or anything of the sort. It's to kind of just generally have an understanding, because we had kind of reached the end of tools available to us to fulfill our responsibilities. And that's really kind of the purpose of the hearing. I think all three of us are familiar with the degree of work that's taking place in the trial courts and the felony courts, and all that's upon your office, the shortage of lawyers that persisted for a period of time that we're familiar with. What I'm trying to glean and understand, and really a lot of the hearing today for me, if I speak for myself, it was kind of the last option, but also to give you an opportunity to be heard as to exactly what was occurring, and I think you've answered some of those questions. Once your involvement in a case concludes and the notice of appeal is then filed, that is off your desk.
Yes, sir.
You are then focused on your remaining dozens of cases.
Yes, sir.
You would not receive any updates or the like until, if we were to either write an opinion or issue a decision in the case, that you may see that come across your desk.
Maybe. I think at that point it would even go through our appeals department at that point. They don't.
Do you happen to know, you said that the office has established a redundancy. In other words, not only the trial counsel of record, but someone else then gets notice. Would it be the local head of the office? Is it still Miss Abel?
No, Your Honor, it's not Miss Abel. It's actually in Baker County now. But no, it's actually a staff member
Okay.
who will receive it, load any of those orders into our case management system, for lack of a better term, so that those orders are then reflective to anybody who pulls up the case. It wouldn't be something that only one attorney would then see.
But that redundancy, the staff member then would bring it to the lawyer's attention.
They would bring it to the lawyer's attention and to the head of the office's attention, and any other steps upward that need to, because they will receive it, file it into the case, and file, we call them alerts, but basically an alert to all of the relevant attorneys.
Okay.
How do you get, I mean, you file the notice of appeal, so you're counsel of record. How do you get substituted out as counsel of record in appellate court here?
So my only other appeal that I had filed was with the first DCA. The 7th, I believe, still wrote our appeals. My understanding is once they filed the brief, they also filed the substitution. That's my understanding. I can certainly check on those issues and make sure. I'm sure that the appellate department has gone through and established additional redundancies that I'm not aware of, but that's my understanding as to how that occurs.
So you've not filed another notice of appeal since this one in January of 2023?
I believe that was the last one that was filed, yes, sir.
So you filed 2 notice of appeals in your,
Yes, sir.
so many cases, I mean, I'm, just from the observations we've seen in being felony judges and being on the court here, we get all kinds of appeals out of felony. You've only had 2 appeals on your cases?
That's correct, Your Honor.
Anything else you would like to tell us in mitigation or for us to consider?
Your Honor, again, I offer no excuses other than It certainly was not intentional. I'm embarrassed to be standing here having to have this conversation with you. It's certainly not intentional. Your Honor, we've established through the office as many ways as we can to ensure that something like that doesn't happen. I obviously have learned a lot about appellate work as a result of this, and so certainly red flags on my end will be raised much more quickly, and I certainly have a better idea of what to look for once that notice of appeal is filed to ensure that, you know, my name's not associated with any issue, whether it's of my making or not.
Let me ask this, just to throw another wrinkle into the world here. On March 19 of 2024, I can't read this judge's hand. Who was the trial judge? Do you remember who the trial judge is in this case?
For Glover, it would have been Judge Blas.
Well, some circuit judge in Duval County has issued an order appointing the Office of Criminal Conflict and Civil Regional Counsel as the counsel for Mr. Glover in this appeal, and it shows a CC to you.
Yes, sir.
Did you get it?
Yes, sir.
So you've been, what do we glean from that? So you've now been appointed to be the counsel again?
My understanding is when we do file our notices of appeal,
Let me just, it's just a contextual for me of.
Sure.
You filed a notice of appeal saying you're the attorney of record back in 2023. You're still the attorney of record as far as we know. That's why you're here talking with us today. And while we are awaiting this hearing, we get an order from the circuit judge appointing you as attorney of record, and I'm wondering if you have any knowledge as to what generated that event.
Yes, and so once that order regarding my appearance was here, and then there was a recognition that there had been issues with the filing, there was a attempt to do any and all paperwork that might be necessary to facilitate his appeal. And so those documents were generated or regenerated again.
Well, let me ask pragmatically, okay, we'll go back and talk. What happens next on this fellow's appeal? Who files what here? You?
It should transfer to the 7th for the filing of the appeal for the actual brief.
What do we need, since this case has come up on our radar, for lack of a better term, what do we need to do to make comfort that we know that that's what's going to happen?
Your Honor, I will ensure that that's what happens, and if that means I have to write an appeal, then so be it.
Well, I don't want you to do anything you're not supposed to be doing if this is not part of the process. We just,
It's
you know,
not,
at the
but
end of the
my-
day, we have a duty under the
Yes, sir.
Constitution, under Marcy's law, to move these things, and we're probably not going to be able to get this moved because we've spent 15 months briefless and recordless right now. I mean, it is what it is. I
think what I'm trying to say is that I will ensure it gets done. If at the end of the day I have to do it myself, it will get done.
Anything? You still with us?
Still, yeah.
Okay, anything else, ma'am?
No, Your Honor.
Okay, well, thank you very much for coming in. We'll send you something.
Thank you, Your Honor.
Safe travels.
Have a safe trip back.